I want to welcome everybody. I am Jeff Taft. I'm a partner at Mayor Brown here in town. I'll let my co-panelists introduce themselves.
I'm Debbie Hamalian, Chief Compliance Officer of Voya Investment Management.
Chris Michaeloff, Senior Director and Associate General Counsel at TIA.
EJ Yurzak, I'm a partner and Director of Cyber Services at Ascendant Compliance Management.
Thanks, everybody. We've got basically a twofold agenda today. The first part of it's going to be a cyber incident / exercise. And then the second part is going to be kind of more of your traditional kind of compliance do's and don'ts and some of the current events that have been going on. So we would like it to be as interactive as possible. We have 60 minutes, so it's unlikely you want to hear the four of us talk for 60 minutes, so it would be good to kind of get some participation, recognizing that obviously that it's a larger gathering than I might have expected, but that's good. That's good. So I think it'll benefit everybody if we can have some different viewpoints as well. Just going to kick it off with what I would call the slide for those who don't have a keen sense for the obvious. Why cyber is important. Obviously, one reason, it's an SEC priority as far as examination goes, and it has been for the past 3 years, and it probably will be as long as it continues to be cyber and the SEC. So I think that's something that's going to be a constant. There's a real agency focus on cyber at the SEC, and it's not just on IAs or BDs, it's on everybody. You've seen the recent release around public companies, so I think that's important. OC has fine-tuned its examinations, I would say, around cyber. First looking to see whether you had policies and procedures, then looking to see whether those policies and procedures actually reflected what you were doing, i.e. they were implemented. I think a lot of people went out and got basically standard policies. We got asked a lot of times for a standard policy that they could take a look at. And I'm not sure a lot of clients or companies were actually marking those up or trying to reflect that they actually showed what they, in fact, do. And I think that's an important issue. It's true for any compliance thing. You're better off not having a compliance policy, quite frankly, than having one that misdescribes what you, in fact, are actually doing. Cyber is an international issue. It's not just a domestic issue. So I think for companies that are global companies, this is a particularly vexing issue. It's a cross-border issue. The threat actors are also cross-border. It's not just a domestic threat issue. So I think that's something, obviously, to keep in mind. I think it's important that now that the exams are coming and people are starting to get written up for some of the deficiencies, that's obviously going to generate more interest internally, I think, around cyber. So that's an important thing. And lastly, but not least, it's a business risk. I mean, cyber is not just a compliance issue, it's a business risk, and it is protecting some of the firm's most valuable assets. Some of that's customer information, but some of it's also crown jewels of the company. And I don't think folks oftentimes will focus enough on the crown jewels. They're spending a lot of time looking at NPI and protecting NPI, but crown jewels are every bit as important. Before we get into the scenarios, I don't know if any of my co-panelists have anything.
No,
Nothing. Let's kick it off.
I would just say I definitely agree about your comment on the policies. I think you want to be thoughtful before you put policies in place, because having policies that are drafted with all good intentions, unless you're doing it, you're really kind of setting a high standard. You may want to think, if you're using an outside vendor to help you, maybe interpose counsel with them, right, so you can have some privilege, outside counsel, and you can start having that dialogue before you take it into your email and your server. I think that.
Yeah, another thing too is like, think about who actually participates in the development of those policies and procedures, because it can't just happen in one area. Compliance needs to be involved, law, technology, sales. I mean, if you involve representatives from across the organization that, quote, have the crown jewels and know what they are, they need to be involved in the drafting of the policies.
That's great. I think one of the things that makes cyber most vexing, obviously, is it cuts across the whole organization. It brings together groups of people within an organization that typically do not work together, do not have working relationships, and I think that's difficult. It also brings a new language to people. As a lawyer, I often find myself being faced with these technological issues that, quite frankly, I have a basic understanding of, but certainly nowhere near the understanding of many of the people I'm dealing with. So it oftentimes takes you out of your comfort zone. Incident response scenario. We have a scenario that we're going to walk through. There's 2 or 3 iterations of it, and then we have some questions between each of the scenarios. I will go through it, but you can probably read it as fast as I'm going to go through it. Basically, we have some customers who have reported receiving suspicious emails from the company. They're requesting certain types of information. Some of the customers forwarded these emails to the company thinking that they look suspicious. The company quickly determined that these were not sent by the company, but is concerned because they had a lot of personal information that only somebody who had perhaps access to company information or the company database would know about these customers. At least one customer, and probably many more who are just embarrassed to admit it, have provided information, including their account password, their bank accounts, and are afraid that funds may be transferred. So that's our initial scenario, and let's just kind of take a look at some of the questions. First question, obviously, primary concerns at this point, and anybody can just jump in, you don't even have to raise your primary.
One thing would be, was your firm hacked? Were you culpable in giving out some of this information in any way, shape, or form?
Other concerns at the outset? I mean, we're 5 minutes into the scenario, but let's, in the back.
Preventing loss in the first place, resetting passwords to prevent them from actually using the information.
I think I would talk to the custodians in a hurry, let them know what's going on, and have them maybe freeze sending any more funds out.
And this is a good question, I think, for folks in the room. You know, at this point, what's the role of legal and compliance? You know, is it more of a support function? Are you taking the lead on this? Who's developing, you know, the facts here, and who's in the room, at least initially?
Yeah, I'm hearing different concerns in terms of liability, in terms of, you know, initial actions. You know, of course, when there is a breach, when there is an incident or a cybersecurity you know, occurrence such as this that we've described here, you know, time is of the essence in your response, and the more time that goes by, the more likely it is that further information could be breached or used against your firm or against your firm's clients. So that's why it's important to get that response right and to make sure that all the stakeholders involved at your firm know what their roles are. So again, I've heard a response being, okay, I'm concerned about our potential liability. I'm concerned about, you know, shutting off access to these accounts, changing passwords. What's the first thing that should be done?
I would say the first thing that should be done is a stop loss. I mean, just you got to find out how it's getting out and stop it. You have to control the bleed or spread of the attack. And I think that's best given to the technology people are the first ones on the base in terms of locking up the environment.
Definitely agree with that, right? You know, you got to stop the bleed immediately, as best you can. Someone raised, you know, freezing accounts, that, you know, obviously is great, but may raise some practical issues too with people who need to get money or funds moved around. You know, kind of thinking about, you know, what's the involvement of law enforcement? Do I involve them because you may have something going on? You know, you may have some insurance, some cyber insurance, and you have a trigger, right, where you have to notify them so you can get indemnification. Do you escalate this to your board of directors, if you're a fund, if you're a public company or not? When do you kind of involve your board to let them know, your IR department, you know,
Yeah.
you kind of get the...
But see, right there, that's it, right? That's everything that starts going through a CCO's head. It's like who, when, where, what, and why, and what's the right sequence of that. Every drill I've been in and every real event I've been in, it's never been very clear. You have a plan. You know, we have a playbook, and it addresses every situation that we've faced thus far, and every one that we can contemplate. But you'll never get all of that together. And I think the communication part is probably the most difficult. And unfortunately, as we go through these things, we'll learn each time, but we'll get hit.
And with respect to the playbook, I mean, do people see calling together the cyber response team at this point? Is there notice that you would send within the company to kind of put people on notice that there may be an incident, they may need to dial in or show up for a meeting? I mean, I think that's an important element because, again, it brings the stakeholders together, but that's really something that everybody's plan, I think, is going to address. But are there ways within the company that people do notify others that there's actually been a cyber event? What's some of the prevalent ways that people typically do this?
So our chief risk officer in charge of the cyber program is the one who would initiate the incident response crew. We have a call tree, and there are certain people that are always on the call tree, and there's others that aren't. They're only there because we believe it's touched their information.
And what about external partners? When do you go out to external partners? Because I think this is a common one. I know people usually like to go out to me around 6 o'clock on a Friday, but I assume it happens at other times, right, during the week. But who are the people who make the determination as to who you need to contact? Is that the same folks who pull the team together?
Yeah, it's all part of the incident response team because we each have our external contacts that we would use. So for me, it would be, do I have to go out to a regulator now, state or federal? I don't know yet until I hear all the facts around it. The law department's going to go out to outside counsel when their trigger gets hit. So I think it really is, if you have an incident response team that is truly representative of the entire organization, everybody will know who to go to when.
Yeah, what's interesting sometimes is, under these state privacy laws, there's kind of a requirement to start notifying people. But when you involve law enforcement, especially Department of Justice or FBI, they don't want you to notify because they want time to investigate and look into the situation, which creates, competing issues. I'm not really sure what the answer is, but it should just be aware it's competing issues at times.
Well, you also have competing issues in play if this particular incident happens, right around the time where your firm had planned to execute, a large number of trades, or maybe there's a merger or an acquisition afoot. Maybe there's some type of large, transaction that's in the midst of occurring, and that's when the incident happens. And so you may have internal competing priorities and concerns as well, where the chief technology officer, chief information officer may be saying, okay, let's lock down these accounts right now. Let's change passwords. Let's go into containment mode. And the CEO may be saying, no, we don't want to jeopardize this lucrative transaction. The trading team may say, no, we got to execute these trades. This big deal going on. You're going to have some conflicting interests internally before you even reach out to your external stakeholders. The other issue I wanted to tee up, though, for the audience in terms of communication, while we're on that topic, how many of you have received inquiries from clients, from customers, asking about an incident, asking about a situation, why is my account locked, or why can't I log in, before you've received any kind of direction from your own firm, and you sort of feel compelled to give that client some information, but you're not really sure what that message should be yet. Does that happen to anyone?
So we have a call center we have a retirement business, and the call center is, the place where we have to do some lockdown, especially when we're getting external intrusions. And their ability to actually communicate to the caller why they cannot get in their account is not, I don't think, exceptional in any way. And I think when you tell a caller that you really don't have any information for them, I mean, just think about it. You get locked out of your bank account, right? Your login credentials aren't working. You need to put a transfer on, and nobody's answering your questions. I think that training of the call center is probably step one, because that's your outward voice.
I definitely agree with that.
Now, let's give some additional facts. As they happen in these events, they tend to evolve slowly, but with the click of the mouse, we now have additional facts. We know that the IT group is finding some evidence that there was a process running on your servers that could copy databases containing customer information. So that's one bit of information we have. Security is also examining an employees and their log files and determines that there's unusual activity with respect to one employee. That employee was logged onto the system for several days, workaholic, right, no problem, and has accessed a large amount of information, customer information. While that employee has access to that information, this conduct, even for this employee, seems a little unusual. So let's kind of take those facts and kind of come up with what the next questions are. Obviously the possible copying of the database with customer information, and it has to be a huge concern for everybody in this room. What are the thoughts though around that? I mean, is this in and of itself something that may, trigger notification immediately? Is this something that needs further investigation? Did it in fact get copied? What are some of the things that you would do to kind of investigate this a little bit more?
Is that employee even physically there? Is it actually them?
It's a very good question.
That's good, yeah.
So that may be as simple as sending somebody up to their office, right? It's just, or having somebody
Or
go
having
by.
their IP address too could be being used, yeah, so you would have to really look into that as well. I think this notion of engaging an external forensics tester is really a good one. I think firms should not hesitate if they don't have the internal expertise that they need to bring in somebody really fast. I think that would be expected by the regulators and by law enforcement, although I'm not sure with law enforcement because they want to conduct their own investigations. We don't have time to wait for them to open a case.
And I think if you are in a position where you may need to retain a forensics or even PR or even legal, it's great to have those all signed up in advance, because the last thing you want to be doing is negotiating an engagement letter with either a law firm or a forensic shop while this breach is occurring. So I think as part of any cyber plan, that's something you should have in place, and probably should have in place multiple parties, because there's ultimately going to be conflicts, or people are going to be staff constrained or resource constrained, and they can't throw the bodies you may need at it. So I would recommend having that in advance.
Jeff, do you advise your clients to have them retain them through you, or do you not, is that not a concern in this space?
We typically, on the forensic side, we do retain, try to have the lawyers retain the forensic shop, simply because it helps from a privilege perspective. It's not ironclad, but obviously it's a helpful fact to have that. If something comes out of this that you don't want to reveal, it's good to have the lawyers retained. We do sometimes retain PR shops as well for clients, but I don't think that's as necessarily as problematic potentially.
I could second the notion of the importance of hiring, a forensic investigation firm, or at least having one, in mind, or possibly on retainer in advance, because those firms will charge a premium to drop everything and come on site right away. But at least if you have a retainer arrangement in effect at the outset, and the incident response vendor will typically try to get a sense of your firm and the data you collect and the organization of your systems in advance before you have an incident, so that the response time is reduced significantly when you do have an incident that you need to bring them in for. They can hit the ground running right away. But you will, in fact, pay a premium for them to drop everything with all their other clients and fly right out and deal with your situation.
Well, I think too that kind of having that third party come in is kind of protects you from internal protectionism, because people who start seeing fingers pointing at them and the systems they maintain may start to put up the shield, and you may not get all the information that you need. So I think the forensics is also important for that reason.
Especially if the board's involved, right? The independent directors at some level get involved, and you really want that independence to come in and take a look and kick the tires.
Just by show of hands, who has a forensics investigation firm either on retainer, or you've at least done some due diligence on them, or have a short list? Okay, several. Sorry, go ahead.
I guess, law enforcement, this is a question that we get all the time, is when is it appropriate to contact law enforcement, and who should we contact? And I don't think there's an easy answer there, but I think some clients typically have pre-existing relationships with law enforcement, and I mean that in a good way, a real positive way. Some have bad experiences with law enforcement, but that's not what I mean. Either because they have former bureau personnel who work for them, NSA or FBI personnel who work for them, or Treasury Secret Service, so that they have contacts within those organizations that they used to work for, or they've just developed through outreach a relationship with somebody in the local office or something like that they feel comfortable reaching out to. I think that certainly helps make a decision as to when and who to talk to at law enforcement. And I also think it gives you somebody to also reach out to kind of on an informal basis. Whereas if you're just kind of cold calling over to the department, the bureau, it's very difficult to get a real read from them as to what this issue is. If you have a friendly person over there, they may say, the third person today was called with this issue. This is going on. This is endemic through the industry, or, we can help you. We've been advising somebody else on something very similar. So I don't know what typically folks in the room do about law enforcement, or whose decision that is, or who even would contact or interact with law enforcement. But I think it's an important thing to have as part of your plan.
Yeah, so in our plan, actually the team, our security team for IT security, now has former law enforcement people. We went out and we hired police officers that are retired. We hired FBI retired. There are a lot of them out there that are looking for these types of roles. Not incredibly expensive. The knowledge they bring is exceptional, and they're the ones who help us with when we go out, because they have the knowledge of when law enforcement would look at something and see it as material enough for their attention.
I mean, certainly, having CISO who kind of understands some of these issues, and a lot of these CISOs are coming from CIA, NSA, FBI, having a rapport, certainly found the FBI very amenable to speaking to people. I think they view companies or financial service providers as victims. If you're a bank or have a bank holding company, it's hard to say, I'm not going to let the Fed, OCC, or other bank regulators know, insurance company, letting insurance regulators know, obviously touch points with the SEC. Maybe one positive development there, Stephanie Avakian a few months ago gave a speech in which she kind of said, look, in some instances, maybe we think that cyber breaches could be dealt with through a deficiency letter as opposed to enforcement action, which I think lowers the tone a little bit, right? I think those are the kind of the big issues.
EJ, have you had, like, in your experience with actual events and tests, do you see firms going out to law enforcement before they go out to regulators?
Yes, and I think there is some hesitation there because, rightly or wrongly, I think financial services professionals are concerned that the information they may disclose to the FBI, for example, may end up in the hands of the SEC. The FBI has assured me that they take the information that you provide them with very seriously, and they protect that information and use it as the basis for their investigation. But I completely understand that there may be that concern that, okay, well, once we divulge this information to someone, even if it's law enforcement, that they may turn that information over to a regulator such as the SEC. It's been my experience that, investment advisors will try to do everything possible to avoid classifying a situation as a reportable cybersecurity incident. In some cases, bending over backwards to say, oh, okay, well, so-and-so, got this file. Well, they weren't the authorized recipient of that file, but they've promised me they've deleted that file. I believe them, not a breach. I don't know if that analysis is going to fly with a regulator, but it's been my experience that firms will try to do everything possible to avoid saying it's an incident. Because the second you bring it to the attention of the regulator, you very likely run the risk of the SEC or your other regulator saying, playing Monday morning quarterback and saying, okay, well, you've had an incident, boom, deficiency or enforcement. Whereas if you hadn't disclosed that issue to the regulator, even if required to do so, they may never become aware of it. So it's you kind of stuck between a rock and a hard place. You have your required disclosure obligations, particularly if you're a public company. Short of being a public company, I've seen firms really go to extreme lengths to avoid saying something was a breach.
Just one final question on the fact pattern here, then we move to a little additional facts. And that's, what if this had involved a vendor rather than an employee, or whether there was access through a vendor? How does that kind of change the process that goes on, at least internally?
So if the vendor, we identify that it wasn't an employee, it was a vendor, how would we react to it? I mean, how would we respond to it differently?
Yeah.
I don't really think that I don't really know of anyone. I think we would treat them the same. I mean, the employee, obviously there would be, some human resource issues there that wouldn't apply to the vendor, but every other step would be, I think, the same.
Yeah, and I guess the things that typically we struggle with vendors is, obviously getting information from the vendor, understanding what's happened at the vendor, understanding, how many institutions may be compromised, because they might have compromised, 20 or 30 other institutions, not just us, and they all may be calling at the same time asking what's happened. So there is a little bit, I think, loss of control, where if it's an employee or it's your systems, you kind of have that at your fingertips. You can hire the forensic person. You bring them in on your schedule. You don't really have a lot of say sometimes what the vendor does. And oftentimes you can threaten the vendor with, termination under their agreement. But candidly, if it's a core vendor and there aren't a lot of people providing that service in the space, you know, it's not like you can just can them overnight and then expect your business to go on without fail. So the termination rights you may have for breaching the contract may not actually, in fact, help you very much, other than, you know, some hammer that you can hold over their head.
I would also look at the potential liability of, you know, the investment advisor or, you know, my company. If one of my vendors was the source of a breach at my firm, I would question whether or not my own due diligence, you know, policies and procedures and you know, actions were adequate and reasonable. I would immediately pull up those policies. I'd pull up my vendor contracts. I'd really try to piece together, you know, what information were we storing with this vendor? Did we run them through our robust due diligence process, or did they sort of fall by the wayside? Have they made some changes on their end and their systems that led to this breach? Or was it a failure on our part to conduct adequate vendor due diligence? Because if that's the case, I would expect, you know, the SEC in an examination to cite me for that failure, failing to conduct adequate vendor due diligence, as we saw, I think, with the R.T. Jones enforcement action.
So so I'm thinking from a different perspective, like when it actually happens and when it's discovered, you identify that it's a vendor or that the data information has, you know, through
Right.
some type of transmission line, it's been accessed, you know that there's been leakage. You reach out to that vendor and you find out where are all the other links of this information, right? We actually did have this happen, and so where we identified that information that was going to a transfer agent was compromised, we had to reach out to them to find out, okay, where are you sending this information under the regular protocols? And we had to put locks on those. So yeah, there is a very different and much more expanded response in terms of what not only your exposure, but that vendor's making your exposure even much broader.
Let's go to the final sets of facts here. So we've hired our forensic consultant, we brought them in, they've started to do some work around the breach. They determined that there was malware provided by a third party. It's accessed the company's system containing employee and customer data. Hacker was able to destroy many of the log files, so it's impossible to really know what was accessed. And then with respect to the employee, just to bring it all back together now, when confronted, shockingly, the employee admitted that he was thinking about leaving the company to go to work for a competitor, wanted to have customer information to take with him, and to cover his tracks, he hired some hackers to come in and put some malware on the system.
That's where it really got bad.
Yeah, that's, he really wanted to cover his tracks. But I think this kind of raises the issue, you know, around notification and some of the other things. I think that we have a lot of information that we can kind of look at some of these things and figure out what the obligations are. I think the first one, obviously as a lawyer, I'm thinking about what are my legal obligations now to notify customers. I know that there's been access to customer and employee information. So basically under most state data breach laws, you know, the clock is now starting to tick, and a lot of those laws give me some leeway. They say within a reasonable period of time, or, you know, as soon as reasonably practical or something of that nature. So I think in a situation where it's become fairly clear, cut and dry that this did occur and there has been a breach, I think the problem is typically it takes a week or it takes, you know, 5 to 7 days to get to the point we've just gotten in 2 mouse clicks. So I think that's one aspect of it. So now we're probably already a week into this event. So now you have to start thinking about going and notifying customers. How are you going to do that? I mean, do you have the capacity to do that internally? Is that something you want to have a third party do? Do you have the call center personnel, for example, to go and handle the call volume that's going to spike up when people start to get these notices? Do you have a third party vendor, for example, who's going to provide or could provide for you some sort of credit monitoring or some other service like that that you can offer to your customers to the extent that that's appropriate or that's required by, you know, Connecticut law or some other state law? I think that's become a fairly standard thing. And again, if you don't have that in place, that's an agreement that you're going to have to negotiate with, you know, pick your vendor. And trust me, they know when you need it. And it's not going to be a good negotiation. It's going to be very one-sided. So again, that's another thing you want to have up front. But just the notification point, I think, is important because it involves, you know, a number of stakeholders within the company. It has ramifications for the brand. It has ramifications for legal. But, you know, I'd just be curious, how is that handled? Who makes that determination within most organizations. Is it a legal call because it's a legal statute, or is it a decision that's made by, again, the kind of the breach response team?
Well, in ours, it's the Chief Privacy Officer's office that does that. They are a division of law, and they're the ones who have the grid for all the state reporting requirements. So they're the ones, and they sit in on every response as well, and they make the determination. But the point you brought out about, it takes a long time to get your ducks in a row to know that what you've got and who's involved and and then it's time to notify states that really, some of them demand within 30 hours of the incident. So you're a week and a half out. How do you manage yourself around that?
Well, I think it's very difficult. I mean, and, you have to notify the DFS if you're a covered entity under their cybersecurity rule. That may not be a lot of people in this room, but for banks and insurance companies, 72 hours, you don't know anything in 72 hours. And whatever you know in 72 hours, the next 72 hours, you're going to know something a hell of a lot different.
Right.
That's just the way it is. I mean, it's a quickly evolving situation. And the facts here come to a pretty neat, clean closure, right? We've got an employee who hired a hacker, and we kind of understand. It's never that easy, and it's never clear whether what information was in fact accessed, what was downloaded. We know they had access, but did they do it? We can't tell because the log files are destroyed. So it's not always cut and dry in the real world. In fact, most times it's not.
So then you're really just disclosing potentials, right? So you have this nature of a breach, and so therefore a reasonable person would conclude that X, Y, and Z has gotten out there, even if you don't know for sure if it has or not.
I think that's right, and I'm of the view that if you trip any of the state data breach statutes, then basically you're going to give notice to everybody. The selective notice to people based upon where they reside, I think that was an idea that 5 years ago was acceptable. That's probably not the way to do business right now. I mean, say, oh, you live in Alabama. Alabama doesn't have a notice that it doesn't require us to give notice, so we're not going to give you. We're going to give notice to 48 other states, but not you. It just doesn't work. It doesn't work that way with employees either. I think you have to kind of give it to everybody. It's just as a matter of, good citizenship, or however you would describe it, rather than parsing all the state data breach statutes.
I want to ask, sorry, go ahead.
Oh, no, this is certainly when your CEO or one of your executives gets pulled before the Senate or House panel and someone from Alabama, a representative or senator is grilling them, why you didn't notify my residents, you're kind of on the hot seat.
I just want to ask, those in the room, how would you handle a situation like this if you're aware that, some data has been lost, whether it was a lost laptop, or whether it was a situation such as the one that we've described here, where information has, gone outside the firm to an unauthorized third party. But perhaps you don't know exactly what data has been lost or has been compromised. Would you treat that as a breach? Would you take the position that, okay, well, I don't know for sure that, PII has been breached, so maybe it's not, or would you go to the other side and say, because I don't know, I have to assume that it was compromised, that PII and other breach notification statutes may be in play here. Has anyone in this room encountered that situation where you're kind of struggling with an incomplete set of facts?
Either through actual or practice, so you don't have to.
Or if you don't want to talk about an actual incident at your firm, just hypothetically, for a friend. Like I said, I see it all the time. I see firms just struggle with that issue and say, we don't know, what do we do? And I say, well, you kind of have to assume.
Yeah, but then you have to weigh out what your assumption's going to equal, right? And that could be a massive response that may not have been. So you're always on the incidents teams, that you have this discussion going on. You're like, well, somebody's gung-ho about going out on notification. Another person's going, whoa, back up a second. This is what it's going to mean. So that's that conflict you were talking about as well.
Absolutely.
I see that issue come up a lot of times with vendors too, where you end up fighting with the vendor, right? The vendor agrees to indemnify you if there's a breach that they caused, and you have to give notice, and then the vendor says, well, I'm not going to reimburse you because you didn't have to give notice. You just decided to do it because you thought it was a good idea and you were just protecting yourself. But there's no statutory obligation here, there's no statutory obligation there, and you get into that fight with the vendor. It's very short-sighted, obviously, by the vendor who, but it does happen. I mean, especially when it's a huge cost that you're asking them to incur, not only for sending it out, but also if you want them to pay for credit monitoring. So the vendor may say, well, look, I'm not going to pay for credit monitoring because it's not required by law, except maybe in a couple of jurisdictions. So that's on you. You make that decision. That's not me. Doesn't say it in our contract, it just says that we'll reimburse you for, legal expenses or expenses incurred, with the breach. And you go back and forth. So, I mean, that's partly a contractual issue, but I do see that from time to time. So it's not only an internal debate that goes on, but it can be a real-world third-party debate.
This is also true for your insurance carrier, too. In cost of corrections, certain types of claims, you have an obligation to notify your insurer of an event. So if you were holding back on notification, you could get denied your claim for coverage.
Having kind of gone through this scenario and just kind of, played that out a little bit, I think probably want to kind of just talk a little bit about some of the things you can do in the beginning to kind of better prepare yourself and kind of some of the things that the regulators expect. And I'll let Chris kick it off, but I'll kind of
Sure.
chime in.
So, thanks, Jeff. So earlier this summer, the SEC OC came out with its kind of Cyber 2 observations. And as Jeff said, they kind of went below just do you have policies and procedures. They actually were looking to see were they being complied with. And as we discussed, interesting enough, they found a lot of issues where people said we're doing testing on a periodic basis. That wasn't happening. They said we were doing training on a annual basis. That wasn't happening. So calibrate your policies and procedures to really what's realistic, what you can do, because it is kind of low-hanging fruit for sure. But the nice thing about the OC guidance is they kind of said, here are some examples of things we think should be in there. And I thought that was kind of actually helpful and things that should be, thought out carefully when you're going back and looking at your policies and procedures. Yeah.
Oh, no, I was going to say, but I just, I thought that was really helpful guidance myself. I think, it really went to see, they were sharing their observations. They also share the fact that they know that these aren't perfect, but that we're all responsible for understanding our business and our vulnerabilities. Policies and procedures can get you in a lot of trouble if we all know this, that if you don't write what you're doing, then you can't prove that you're doing anything. The guidance about just the types of surveillances that are on the systems was very helpful. These patches that are going out. A lot of organizations now under their fees are squeezing, right? And so the costs of things is being tightly controlled. Patches may not get deployed. When they don't get deployed, it can be detrimental. Sometimes patches get deployed too quickly, and it's detrimental. So there's a really tough balance to keep with all this.
I think the patch point is very good because the regulators are always like, you should patch, and it makes perfectly good common sense to patch, right? The problem is that for most large organizations, whether it's law firms or IAs or banks, you have customized software, right? So you can't just run that patch that Microsoft has put out. You need to test it, you need to do a whole bunch of different things before you can deploy the patch. And I'm not sure the regulators, at least some of the state regulators, have a real appreciation for that. How that customization works and how that precludes you from immediately just adopting and running that patch like I might do on my home computer, right? There's a big difference there, and I think there has to be some recognition, because if you just run the patch without testing it, it could bring your whole system down, and that's going to be just as bad as not having the patch, if not worse.
I completely agree with that point, and I represent one of those firms that helps customize cyber policies, and exactly to that point, when we're working with investment advisors that have proprietary trading systems or certain software that, for one reason or another, for compatibility issues, has to maintain a lower version of Java or a lower version of some other software just to run properly. We've helped write the policies that say, okay, the firm will patch on a regular schedule, except where an exception has been granted by the CCO or by the IT department for software that the firm has chosen to intentionally keep at a deprecated level for compatibility issues, because you don't want your trading system or your OMS or other software to suddenly fail because you took an overly restrictive policy and said, okay, we're going to apply a patch the second it comes out. I think it needs to make common sense.
Yeah, so like for your trading systems, versions come out faster and faster now. We have Charles River as for our equity, and they released a version that was so expensive that it made us go back in and find out whether we're going to continue with that vendor, because it was such a magnitude of cost. The business was saying no, and if we don't take it, we can't put the patches in that we need to have. So you really get into a budgeting issue
Right.
So the policies you helped draft had some language saying patch has to be done or can be avoided if the CCO approves it? Is that?
Yeah, we put some language in there that it was either the CCO or, I think oftentimes we would make it at the level of a information security committee that had input from a CCO and, the trading team and, the IT department, so that everyone was weighing in with their appropriate concerns.
Because obviously the concern is, how much can you really evaluate? If someone comes to you and says, I can't put a patch on, okay, you assume,
Right.
unless you have some kind of background, right, that's always kind of.
Well, and I've asked the SEC, what do you consider a reasonable patching level? Completely not expecting them to give me any answer whatsoever. And I was actually surprised that the cybersecurity examiner, conveyed, again, off the record, but conveyed its facts and circumstances, and it depends on how frequently the vendor puts out a patch. They said if the vendor puts out a patch, once a year and you're one patch level behind, probably not as big a deal from a deficiency standpoint. But if the vendor's patching on a weekly basis and you're 52 patches behind, you're probably going to get a deficiency. But again, it's facts and circumstances.
But I think another thing that's come out of this discussion that I think is important to remember is that if you have exceptions within your policy, and I think that's perfectly reasonable to have exceptions, make sure that there's somebody who's responsible for approving it, make sure that you document it, and make sure that you retain it, and make sure that you revisit it on a regular basis. No exception should really last forever. No exception should last forever. And really, you should be revisiting them on an annual basis, especially if it's technology related, because it's an important aspect. It may have been appropriate at the time, but a year later, a lot of things change. I see a lot of policies that either don't have exceptions, and people make them anyways, or that they have exceptions and they're not accurately tracked and cataloged. I think that's a key point. I mean, it's no different than anytime you are deviating from your policy, you should have, and the exception and the reason for it should be documented. We're not going to do it because it would cause us to have to do X, Y, and Z, and I think that's reasonable. It's much more effective from the perspective of telling a regulator to do it beforehand than to come up with it afterwards, because it just looks like post hoc rationalization for why we didn't patch, or we didn't do X, or we didn't do Y.
And that's like risk acceptance, right? So you have a ton of risk and you've got to weight them. What's the probability of this happening in our organization? And then it becomes a higher risk item for the higher probability items. And also, I don't know about the rest of you, but with cyber programs, there is an argument that it should be managed by the risk organization within the firm itself that performs risk assessments. I think that is a really appropriate assignment for them as they touch all the business. I don't know about you guys, if you heard.
I think having a formal risk acceptance process is important. You're not going to have 100%. Things aren't going to work 100%. You're going to have, vulnerability tests, penetration tests. They'll find exceptions. You'll have a time period to kind of cure them. You'll be rolling out new software, moving to the cloud. So having a formal risk acceptance process where various business people have signed off and say, okay, I understand. This isn't, clearly it's not illegal, right? Because if it's illegal, I can't do it. But, we're doing this and we understand these are some of the risks and we're moving to close out these risks by this date, I think is something I've seen and I think it works effectively.
It gets back to what we kicked off the conversation with. Cyber risk is business risk, and business risk impacts the entire firm. So by virtue of that, it's a firm-wide risk. It's not just relegated to the IT department or the IT geeks in the corner. It impacts everyone at the firm.
Chris, I don't know if you want to just mention something,
Sure.
things that have been going on at the SEC,
Yeah.
and then have EJ talk a little bit about some of the state law developments.
Yeah, absolutely. So as people may know, the SEC formed a new unit. I think they're up to 6 units now, formal units in enforcement. One is a cyber unit. Rob Cohen, who headed the market abuse unit, was tagged to head this group. I think they have roughly about 30 people. They seem to be more focused on a lot of the ICOs that are going on, really kind of more traditional fraud. But the concern is obviously as this group exists and continues to grow, they'll be very focused on cyber. They'll be getting more specialized in cyber. And the concern you always have is, will they look for cases to make, right? Certainly you have an asset management unit that didn't exist 5-6 years ago. It exists now. And lo and behold, the amount of actions against asset managers increased. So that's out there. Chairman has made it a priority. It's been a priority for OC for quite a while. We learned about the Edgar breach with the SEC. SEC is taking a look at it. I think, the one, I don't think anyone really, jumps for joy and says, great, the SEC was hacked. Obviously, it's important to our country, and important to all of us to have a, robust regulator with adequate controls in place. But it's a learning experience for sure. Last thing to point out is in February, the full commission came out with some guidance on cyber risk disclosure and dealing with MNPI, kind of in the wake of the Equifax issue. It doesn't really, and the commission puts a footnote in the release that says, doesn't apply to regulated entities, advisors, broker-dealers, exchanges, et cetera. But if you haven't read it, I'd say read it, because it's actually kind of interesting, because you begin to think about some disclosures that you want to make, the processes to have controls around cyber. And the other interesting thing about it is, how to deal with cyber incidents. When do you black out stocks? If you're public, when are you going to black out the stock for your employees, your officers, your directors? Very complicated, right? When you're dealing with cyber, as we talked about, you don't really know the full magnitude when something happens. Sometimes what you think you know is totally wrong. You find out in 48 hours it's the exact opposite. So you're kind of under the gun, if you will, to come up with the right answer. But clearly you don't want someone exacerbating a situation by doing a trade that now is subject to intense scrutiny. Who approved it? Why wasn't the stock blacked out? So I definitely say it's worth a read. I think it's maybe 15, 20 pages, double spaced.
Yeah, and that actually drove a change in our code of ethics and our MNPI policy where, after reading that, you could see we're publicly traded. So our employees, they go through a number of blackout periods before earnings, so they're used to it. I've now decided that we're just going to, the minute I'm brought into an event and once it starts to look like it's getting to a point and I have enough employees around, in the discussions, we're just going to lock it up. It's only employee trading in Voya securities. So we wouldn't, maybe it'd be a much broader impact for some of you in your organizations that you wouldn't make such a hardline decision so early in the process. But that's really, I think, the only way that I can feel comfortable with it.
Oh, it's interesting, right? Because you have a fairly high, or a person who did cyber at Equifax was being sued by the SEC and also was indicted by the Department of Justice. As far as I know, as of yesterday, that matter's still being contested. So it'll be interesting to see how that issue, when that issue moves forward, really, how they're applying materiality, right? What did this person know? What did they not know? And probably part of the defense is, and the company didn't black out the stock, right? I thought I was free to trade. The general counsel, the CCO, they all knew about this, and my trade went through. I didn't really know the full magnitude, but I think that's just an interesting dynamic to keep track of as well.
Yeah, I think at minimum your Section 16 people should be the ones that are locked up right away because they will be privy to the incident.
Right, and then it'll be apparent, right? Because if they trade and you file your Form 4s, and then a day later you're filing an 8K to say, by the way, we had a cyber incident, not the best.
EJ, talk a little bit about state law, maybe?
Yeah, I'll talk about state law, which may or may not directly impact those in this room, but it's a sign of things to come. It's a sign of where we're headed. The New York Department of Financial Services came out with its Cybersecurity Regulation, which impacts covered entities as defined in Section 500 of the regulation. In a nutshell, it's going to be banks, it's going to be credit unions, it's going to be those types of entities that are subject to the jurisdiction of or licensed, chartered under the regulation of the New York banking law, financial services law, insurance law. So it doesn't directly impact many SEC-registered investment advisors. That being said, a lot of SEC-registered investment advisors who have affiliates that may be subject to the regulation are certainly taking notice. But it's also, I think, important to take a look at what the regulation requires because it is a sign of where we're headed. There are various, state breach notification laws and different state cybersecurity laws on the books. New York's, I think, is one of the most stringent that's on the books right now. So I would take a look at it from a security standpoint, a best practice standpoint. From a regulation standpoint, it's certainly one of the most onerous to comply with. In a nutshell, what it requires is that entities develop, a robust cybersecurity program based upon an informed risk assessment. the development of cybersecurity policies and procedures on everything from data governance to an inventory of devices, monitoring, and so forth. But it goes a step further. So the New York Cybersecurity Regulation, fortunately, was phased into implementation, and most of the regulation is currently in effect. As of mid-February of this year, actually, firms were required to submit their first certification of compliance with the regulation if they were subject to it. However, September of 2018, most of the remaining facets of the regulation take effect, including the requirement to conduct annual penetration testing, the requirement to impose multi-factor authentication, and requirements such as that, the requirement to conduct mandatory cybersecurity awareness training for your staff. So again, I'm talking about things that are cybersecurity best practices that this regulation in New York now requires, but I think other firms are really taking notice of and saying, hey, you know what, we're not required to do that, but not a bad idea, to protect the firm, to protect our business risk. The one requirement that will not take effect until 2019 is, I think, one of the more onerous aspects of it, and that's vendor due diligence. Vendor due diligence with a cybersecurity twist in terms of really getting a good handle on who you're sharing your personal data with, who you're sharing critical information with, what data are you sharing with those vendors, what are they doing with it, do you have a good handle on your contractual provisions with those vendors and breach notification provisions with respect to those vendors, and do you hold your vendors to the same security standards that you yourself adhere to and convey to your clients? Honestly, in a nutshell, to me, a lot of what the New York Cybersecurity Regulation will require as far as vendor due diligence in 2019 echoes a lot of what the business continuity rule for SEC rule advisors would have required had that business continuity proposal still been on the books and not been withdrawn. So again, New York, first in the nation to come down with a really strict set of requirements. If you have affiliates that are involved in banking or credit unions and so forth, or again, if you have investors that simply want to hold you to a higher standard, you may be aware of these already. Other states that, again, are really following suit or have had rules on the books already, but it almost seems like a race among the states to see who can be the most strict in terms of their requirements. Vermont, California, the other one that we have on the screen here, Colorado, recently have all come out with increased cybersecurity regulations for residents of their states. Why is this important? Because when you have a breach, when you have a cybersecurity incident that's reportable, unfortunately, as of now, there is no federal breach statute on the books. There have been several attempts in Congress to push a federal breach law. All have sat there and perished. There's currently one that was proposed December of last year that's still has a potential chance to make it, but I feel like these regulations, they're raised every year and then they wither on the vine and die. But you really have to look at each state's statute to determine within that state, how do they define personally identifiable information? How does that particular state define a reportable breach? And if it's reportable, how does that state require you to effect that response? Some require notification to the Attorney General, some require notification to the affected consumers with a lot of detail. Some require notification to consumers, but at a high level. So you're sort of dealing with conflicting state breach statutes where, okay, I have to include how the hacker got in to this state, but I have to just tell this state, residents, okay, your information may or may not have been compromised, but I can't really get into detail about how. And one other state that I'll mention, Tennessee. The various state breach notification statutes all in some sense or another have exceptions to what may be a reportable incident. A lot of them will say if the information was encrypted and the encryption keys were not also compromised, you can say with reasonable certainty that the information was not compromised, not reportable. In Tennessee, for example, however, that encryption exception has been withdrawn. So even if the information was encrypted in Tennessee, you are still required to notify residents of Tennessee. Again, this is just sort of a sign of the times where we're headed. In discussions with NASA, the state securities regulator, there are efforts underway at the state level to really try to harmonize and consolidate and really get a sense at the state level of, can we come to some consensus as what a state breach notification statute should look like that's fairly uniform, similar to the efforts at the federal level to come up with a federal breach notification statute. That remains to be seen, though. There are discussions underway.
Do you think the potential for that is going to become greater with GDPR, where, the federal government will say, look, we do have to do something more uniform? This is like insurance law. It's like, in securities, we have central federal law. But in the insurance world, where there's so much potential for abuse, and I think it lives on with due strength because of the fact that we don't have a consistent set of regulations governing that business.
I mean, I'm actually surprised, or maybe I shouldn't be, that a federal breach notification statute has not been adopted by Congress. I remember, telling an audience, 2 years ago, Congress can't agree on much, but hopefully they can at least agree that a breach notification statute that's uniform makes common sense. But I've been proven wrong that Congress can get that passed. So I'm not going to make that kind of promise anymore.
Yeah, I'm just not sure, where I live doesn't matter when I
Yeah.
get informed. I want to know.
It's a good point, yeah. And I think under GDPR, with the abbreviated timeframe, we're going to sort of see a consensus one way or another as to what the minimum, set of requirements is. That's a good question.
We are running short on time, so I don't necessarily want to just rush through the slides. I'd be more than happy to take questions, I think, from the audience. You've all been very silent. We've only had 1 or 2 questions on the little laptop here. So if there are questions or things that people want to ask, we'll be happy to address them.
Excuse me. So, in regards to GDPR, are you finding yourselves, even if you're US-based and it's not affecting you, if you're more of a global entity or you're working with a global firm, are they in the market more adopting language in contracts to be more compliant? I know with us, we have a parent in the UK, and there's definitely pressure on us to adopt more GDPR compliant language, even if we disagree that the contract would fall under that regulation. Is this kind of a similar trend, or is this kind of more of a unique thing for us?
I'm certainly seeing it on my end in terms of firms kind of moving to that common denominator, that because GDPR is going to impact maybe a subset of your organization, the firms are sort of moving in that direction. I get the question all the time, does GDPR apply to me? Does GDPR require me to do anything at my firm? And it's often not a simple answer. It involves an incredibly detailed analysis of what data do you maintain, who are your clients, who are your investors, what are you doing with that information? Are you a processor or controller under the regulation? Things like that. So it's often not a short answer. Regardless of the answer, though, I am seeing firms kind of move in that direction and say, okay, we're going to end up here anyways. It's inevitable. Let's just start the process. I don't know if the co-panelists here are seeing anything similar. It's I think a lot of firms have been preparing for GDPR for a while, and it's catching other firms by surprise.
I think
On the vendor side, what's the receptivity of third-party service providers to enhance their contractual clauses from an asset management firm? Is it a range, or are most people on board?
My experience with the contracts is it's very different. I mean, I find vendors, obviously fighting not only the provisions, but also, the indemnity, because it's potentially a significant financial burden on them. In some ways, the DFS's regulation imposing these types of obligations on third-party service providers and what the banking regulators historically have provided, I think has beaten and chastened some of the vendors to basically be understanding that they're going to have to accept these if they want to be in the financial services space. You've even seen it on the cloud side where people have started to allow examination and things like that. So I think it's inevitable. I think every regulator is pointing to vendors as the biggest, weakest link that people have.
Yeah, that's, in your procurement process, it's somewhere to look to, is that, when people order data software licenses or all sorts of different types of interactive services, and what we've done is we've actually, within our procurement group, installed a cyber risk review group. So as part of the total due diligence, you've got specialists who know what questions to ask of the vendor. And we actually have eliminated vendors for their inability to be able to commit to complying. It usually is through the indemnification because they're not going to guarantee what they can't control. So that's kind of caused a little bit of friction because people want the data service, or they want that service, and you have to tell the business that they can't have it because we have the cyber risk.
One final question.
So we're an SEC registered investment advisor at a bank. So the bank, as you guys have been talking about, they have lots of, IT, cybersecurity, but as a registered, as the affiliate, I know very little about what they do or how they manage their policies, but I'm assured, don't worry, if the SEC walks in, we'll be able to, provide, X, Y, Z. Should I'm a little concerned in that I worry that they're just concerned about banking stuff, and they might not be concerned about registered investment advisory types of things like the SEC is. So am I like, overreacting? Should I just sit tight?
No, you shouldn't sit tight. The thing is that what I've heard is that the SEC expects the CCO, the investment advisory affiliate, to know what's happening at the parent level. You're to treat them as if they're a vendor, and you're to test them as if they're a vendor.
Yeah, it's a great question. Actually, tie this whole panel together because we were discussing this, before the session. That I imagine many in this room have affiliates, parent companies, subsidiaries, and so forth. I've been to firms where I've asked, the investment advisor entity, what is your incident response plan? And the answer that I get is, oh, we rely upon our parent company to do that. And I say, yes, but what's your policy? Show me your policy. Oh, well, they told me that if we have an incident, they'd show me the policy. I said, no, what's your policy? Like, show me the policy. And they say, well, I've never seen it. I'm not sure if that's been the experience of anyone in this room, but I think if the SEC were to come on site to your firm and say, what are your incident response policies and procedures, or to the point that we're talking about, cyber risk is business risk, forget about the SEC for a minute. If you have an incident and time is of the essence, do you have that procedure handy that you can immediately pull up, or do you have to make phone calls to your parent company first? Are you going to lose time in that process?
Would they put you on a call tree? Would they agree to do that?
I don't know. I've never,
Yeah.
asked them, but.
I would meet with the unit that's responsible for it, and
Well, and we did, and we talked about things, and she, and I saw a very scaled down policy kind of thing that really didn't say anything.
right.
Which,
Well, so that's the other problem too, is that, the secret sauce of the program is not going to get revealed to you because for good reason, right? You don't want your map getting out there. So they gave you the summary of the strategy, but they're not giving you all the dirt, which you're not expected to know that part of it, but you've got to be able to question the responsiveness of the program. And I really I'm included on every call tree.
I think we have now gone over time, but no, that's fine. I just got, people had some questions, but thanks, everybody. And
Thank you.